The case study between New York Times versus Sullivan and Gertz versus Welsh by Aisha Key. The first case study in New York Times versus Sullivan, the parties include L.B. Sullivan, the City Commissioner of Montgomery, Alabama, versus the New York Times. Here are the facts. The New York Times published a full-page ad entitled "Heed Their Rising Voices." The publication directed a wave of terror of civil rights participants in the South. Some statements in the ad were false. However, the ad never mentions the plaintiff's name. He felt the claims were indirectly pointing to him, since his responsibility was to govern the police activity. The defendant claimed that it authorized publication of the advertisement because it did not have any reason to believe that its contents were false. There was no independent effort to check its accuracy. The plaintiff demanded that the publication be retracted. The defendant did not see how the plaintiff could see that the advertisement reflected his leadership. Sullivan felt that his reputation was damaged because he was responsible for the police department and one of the commissioners of the state. What must the plaintiff prove to show defamation? Under Alabama law of publication, a libel is per se if the words tend to injure a person in his reputation or to bring him to public contempt. The jury must find that the words were published of and concerning the plaintiff. Once libel per se has been established, the defendant has no defense as to stated facts unless he can persuade the jury that they were true in all their particulars. The constitutional guarantees require a federal rule that prohibits a public official from recovering damages for a defamatory falsehood relating to his official conduct, unless he proves that the statement was made with actual malice. The New York Times versus Sullivan U.S. Supreme Court's ruling. The jury found the ad libelous per se and actionable without proof of malice. Furthermore, the defendant did not verify information and had no reason to believe statements were false. The U.S. Supreme Court delimits a state's power to award damages for libel in actions brought by public officials against critics of their official conduct. In this case, a public official's official conduct recovers damages for a defamatory falsehood by proving that the statement was made with malice. The jury awarded the plaintiff $500,000 in damages. The second case study is Gertz versus Welsh. The parties of this case are Robert Welsh, a magazine publisher, and Elmer Gertz, an attorney who brought a suit against a local police who killed a child. The petitioner was considered a private person. The defamatory statement about Gertz, the petitioner, is that he was an architect of the frame-up. It implied that he was an official of the Marxist League for Industrial Democracy, originally known as the Intercollegiate Socialist Society. This ideal proposed that he was an advocate for the violent seizure of our government. This labeled Gertz as a Leninist and communist frontier. The statement also reported he was an officer of the National Lawyers Guild, which is a communist organization that probably did more than any other outfit to plan the communist attack on the Chicago police during the 1968 Democratic Convention. Nothing was done to confirm the accuracy of these allegations against Gertz. Actually, the writer made no effort to verify the accusations. He also included a photograph of the Elmer Gertz, the petitioner, and Richard Nuccio, the policeman prosecuted in the suit, that captioned, "Elmer Gertz of Red Guild harasses Nuccio." Published multiple times, this article debuted on newsstands throughout the country. Gertz was an attorney, and considering the facts of the case, damaged his reputation as a lawyer, hindering his integrity as a professional. What would I have done differently to avoid the lawsuit? In this case, Gertz versus Welsh, if I was the writer of this article, I would have verified all facts meticulously. It is a moral standard and a code of ethics to gather all information from a credible source. As a PR professional, the public observes all information as credible, so it's my duty to make sure all information is accurate. If deceived by sources, I should create and include all sources of information and list a clause by awareness of truth. In addition to my publication, I could allow the subject an opportunity to discredit information and reveal both sources. Lastly, use self-censorship. Let's define defamation in the state of Kentucky. Kentucky defines defamation as causing harm to the reputation of a person or business by communicating to a third party via words that are false and meant to humiliate, degrade, and incite contempt or hatred. Statute of limitations. The aggregated party must prove a defamatory statement was made within 1 year of when the statement was made, while the statements are untrue. Public figures and private figures treated differently under Kentucky defamation law. Kentucky views public figures as people who are generally recognized either by their status as a celebrity or public office, seeking elected office, holding a position of public trust, or possessing name recognition. A reasonable person can identify all fall within the definition of a public figure. Under Kentucky state law, to bring a defamation of character lawsuit, public figures must prove actual malice exists on the part of the offending party. Private figures, on the other hand, only need to prove that the defendant acted with negligence or reckless disregard for the truth. Defamation defenses in Kentucky. Kentucky law allows for truth, opinion, and general reporting as valid defenses in slander and libel cases. If the truth defense is employed by the defendant, it's incumbent upon the plaintiff to prove the statement was made by the defendant. Kentucky is a per se state. Defamation per se constitutes a statement that inherently defamatory, accusing someone of having a repulsive disease, criminality, incest, or promiscuity, and uninvited seduction is defamatory per se. In cases such as these, the plaintiff can sue for damages without having to prove actual damages because the defamatory statements are by themselves defamatory. Opportunity to retract, conspicuous and timely. News agencies can mitigate defamation damages if they correct or retract the contested statement. Potential plaintiffs have 10 days to demand a good faith correction or retraction. According to the Kentucky statute, any retraction made in a timely manner and be conspicuous. So what did I learn after reviewing both of these cases? In the case of publishing information as it relates to public figures and private persons involving public affairs, the press should use self-censorship in its speech and opinion. Although information may be published utilizing freedom of press, does not mean it is limited penalty if injury to a private person or a public official. I also learned that the public figure test is an ongoing debate determining case by case who meets the criteria. Furthermore, dependent upon public or private individuals, if suffer injury, recovery is limited. Defamation is a necessary law that protects people from slander and libel. However, it is important as the press to publicize all particulars in content as accurate.